Start with the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
All right, Tuesday, February 18th. Start with the public forum. Anybody in the room, online? Online, there is a hand raise option. Unmute your mic. See any? Okay. All right, close public forum. We'll move on to the agenda approval. Anything to add to the agenda? The agenda is approved. Administrative business.
Okay. We have the minutes of February 10.
We had the chance to read the minutes. Any corrections? If not, is there a motion?
So, I'll second it.
Motion by Kent, second by Dave. All those in favor?
Aye.
5-0. It's nice when Brad's in here.
Okay, next we have early checks in the amount of $8,638.07.
Conflicts, anybody got any questions? If not, I'll make a motion to approve the early checks in the amount of $8,638.07.
Second that.
Motion and a second. Any other discussion? All those in favor?
Aye.
5-0. No. It's getting colder.
All right, then next we have a change order.
Just gonna put this one. Just the prior year?
Yep.
Okay.
Okay, and the last thing is, in your packet, there was a resolution for the Rural Opportunity Zone Student Loan Repayment Program for the calendar year 2025.
Any questions about that?
How long have we been doing that?
Long time, since before I was on.
Before I, yeah, well, that says, that says before me, so.
And how many people we retained in Marion County using this?
That is a great question. We sponsor 3 per year, and so since they can stay on for 5 years, we have kind of a long waiting list. I'd have to go back and look and see how many have gone through the program, but we don't always know if they end up staying after the time frame. They have to stay here during the time frame that we're doing the program. And if they move away, then they're not eligible. But that's all tracked by the state.
There's no requirement that they stay any time beyond.
We've discussed it about every year since I've been on the commission, and you know, personally, I feel like that, you know, if we can try to maintain, even though we can't force them to stay beyond the contract period, it's still a good thing.
Yeah, no, you want it to be more rigid, but like, I see a lot of Tabor families, just the fact that Tabor brought them at one point in their life, then they have a family and they move back. So they know of where we are. I know this is different, but they try to keep a positive memory of the place and maybe they come back.
Well, and I only know of one that moved away during the time that we were on there actively repaying, and so then we didn't pay the rest of their, commitments, so.
Well, any other questions? If not, I'll move to approve resolution 2025-06.
Second.
Second by Kent. Any other discussion? All those in favor?
Aye.
Aye. 5-0.
I could try to pull some more information together on that as well. Oops.
Know what the state allows us to do too.
Otherwise, that is all I have.
Okay. There we go. So I didn't have the chance to put together an official report for you for your packet. I will have one for next week, but I did want to let you know a couple of things. The tentative date for the tax sale looks like will be probably April 17th, which is a Thursday. Is that your birthday or something?
We don't need to go there. That's the easy one for me to remember though.
Oh.
It's my parents' anniversary.
But that's the date we're tentatively looking at right now. The valuation notices will be mailed out by Postalocity on the 28th of this month. They are dated March 1st. They will, taxpayers have 30 days from the date of the, on the notice to go through their appeal process, to begin their appeal process. The building out at the Park and Lake is basically completed. There is some groundwork that we need to do out there. The tractor is ready, and it was, they did not have to do all of the work that they thought they might have to do, so, but we have to still go pick it up. So Isaac is trying to coordinate that right now to get that picked up. The loader was taken out of the ditch. I talked to Steve this morning. He said they were able to roll it over and let it settle. They were able to start it, drive it. It has some, the windows are broken and it has some body damage. So, but as of right now, it runs. So that's good news. Gosh, I've talked with a lot of departments today.
You know, does our insurance cover that extraction out of the ditch?
I will have to check on that.
I think it'd be cheaper.
They don't cover towing, so I would doubt that they would cover that removal, but I will check. Chuck told me today that it looks like March 10th is the delivery date for our ambulance. Then we will have to go through the steps to get it certified with the state before it can be placed into service. Let's see. What's that?
Be nice if we had it now.
Right. Let's see, who else have I talked with today? Marcy told me that the snowfall totals have been updated south of Highway 50 to a higher amount. So that area of Marion County is looking to get towards the 8 or plus inches is what the current projection is down there. I do know that she, in advance of the storm coming in and the low temps, she contacted all the cities and the different areas to find out if anybody was going to be offering warming centers. So that's all, if that need arises, if the electricity goes off or something, then she's got that in hand already. Let's see. A few departments were supposed to be taking a tour of a facility in Manhattan tomorrow, and that's been canceled due to weather and some other factors, so hopefully that'll be rescheduled. And I know there are more things just from today, but I can't think of any more. Does anybody have anything that they're wondering about, questions about?
Is anybody gonna go to this Tri-County Free Fair?
Yeah, you do have a specific invitation to their event this Friday.
As far as RSVP?
Oh, yeah. Sorry, I gave that one to
Should we
you.
do that individually or Ashley?
I think you can handle it whichever way you want to, so,
Yeah, just convenience. If you knew you were gonna go, they could probably put you in. I can't commit to anything right now.
as of right now, does anybody know that they're planning to go to that? Okay. All right, does anybody know that they are not planning to go to it? Okay. Okay. So Kent is maybe our only maybe. Okay,
Depends on whether my wife would be interested.
all right, well, if you wanna just let Ashley or I know, then,
Those are televised shows. That's on RFT.
What day was it?
Friday.
it's Friday evening. They just need to know by
This
Friday
Friday.
morning.
No, I won't be here.
Okay,
I'll be in South Dakota.
okay. I put your name with a question mark.
Like normal.
All right.
The weather and the mood.
Yeah.
Anybody have anything else? I did send you information by email about the last planning session that we had when Wichita State University came in here and led a couple of sessions for us, for the commission at the time. And so hopefully you all received that information just so that you knew kind of what was discussed the last time. Since we do have that planning session scheduled, I assume you still want to do that next Monday at 9 o'clock? Okay.
Get the back.
I'm gonna try. I'll be driving back on Sunday, and I don't have a room for Sunday night, so
Okay.
Okay.
I'll either be sleeping in the truck or I'll be here.
Okay.
Somewhere,
One other thing on the tax sale, we have 19 properties included in the sale right now, so.
We started off with 22, 24.
I
A
don't
few dropped
remember,
off.
it's been kind of a long time getting here, so.
will most of those make it to the sale, or half of them get paid off?
They usually have one or two that pull it together somehow.
They can still pay
Yeah.
up
Wait,
to, right, so.
Is there a 30-day grace period for them to reclaim that, or am I wrong? Am I thinking those tax sales?
So on the tax sale, there is a time frame that they can't just go and pay after the sale, but there is a time frame for everything to be filed and for the to make sure that everything legally is in a row. And I don't remember off the top of my head what that time frame is, but I can ask again. Because they discussed that on the day of the sale, but I don't remember that. But it is somewhere around that 30-day time frame.
Not that I've been involved in one, but I think that's been mentioned in the
Yeah.
something similar.
There's vehicles. It's a whole different ballgame. Just because you got the property, you gotta go through a whole different process to get the vehicles off.
But I can find out that, I'll follow up in a memo or in my report, just with the information on that.
I guess one thing, Isaac asked me about some bunker blocks for that building to reaffirm that backside. I have some at the house that I could deliver for whatever fair market they are, if they want to do that. So that's up to you guys.
Can you explain what that is and like what the approximate cost
They're
is?
2x2 chunks of concrete, anywhere from 4 to 6 foot. I think he priced some out of Emporia for $40 a piece. But then we'd have to freight them over here some way somehow. And if they get the tractor back, I could bring them down exactly. I've got some 4-footers, so I mean, they could come out, or if we needed to double stack it, it just,
How many is he looking at needing?
well, at least 6. Well, building's what, 30-some foot. Figured they needed to go out a minimum. If they just use one, we may need more than that once from whatever. I guess I'd be willing to sell the ones I've got sitting at the house that I probably never use again. So.
Isaac has an allowance to spend without going over, so. The department head make that call. If it's not that, you're only talking about that many dollars.
6 times 40 is a whole lot.
Well below his limit.
If they ever get the tractor back, then they can handle them. Big chain that'll pick them up. Just whether or not we would take some of the ones I've got, if that's proper.
Okay. I'll talk with Isaac about it. Does anybody have any objections to purchasing them
If they're needed.
if they're needed?
If they're needed, then we can get them at a
As long as
cheaper
they're
rate.
uniform and fit.
I would go ahead and have him provide me an estimate of what it would cost from the other
Yeah.
supplier too, so.
I thought you told me $40 included.
I understand, but I wanna see something written from him, so. I think that was all I had for right now.
I think Sharon said she was gonna be online, so. I don't see her. Yeah, I do.
Yeah, she was on earlier.
There, Sharon?
Good afternoon.
Alright, there she is.
Can you all hear me?
Yes, ma'am.
Okay, very good. All right, I have three things for you today. First being Planning Commission case PC 25-01 and discussion concerning compliance with the Sunflower Wind Project, and then also a special event permit application for a temporary asphalt plant. So I'll go ahead and start with case PC 25-01, and I cannot see who's an attendant in person. I don't know if Mr. and Mrs. Kane are in the room or not. Okay. Okay, so Scott and Tamara Kane have requested this conditional use permit for a small cabin on their property to be used for their, at this point, for their growing family. They have some teenage children who are getting to the point where they're close to moving out, but not quite there yet. And as an alternative to building onto their home, they decided to they would like to build a small cabin instead. So there, in the zoning regulations, there are three parts to this that would require a conditional use permit. One being the second residence on a parcel, the second being the size of the home, 750 square feet or less is considered a non-traditional home in our regulations. And then thirdly, once the cabin is no longer used for their children, they may in the future like to rent it out for a short-term rental. So those three items were discussed and considered at the public hearing on January 23rd. And the Planning Commission recommendation was that the conditional use permit be approved, and with the condition that if the cabin is used for short-term rental in the future, it must comply with the then current zoning regulations. The owners must maintain annual registration with the county as a short-term rental and abide by all regulations pertaining to short-term rentals and must be reviewed annually for compliance. These conditions of approval are subject to change as there are certain conditions included in the registration that may be updated from time to time. CUP holders will be notified prior to annual registration when conditions have changed to allow a reasonable time for them to comply. So that portion is mainly for if they choose to register the cabin in the future as a short-term rental. There were no objections at the public hearing. To my knowledge, there has not been a valid protest petition filed, and the recommendation passed 8-0 at that meeting on January 23rd. Do you have any questions about this CUP application?
I just have one question, Sharon, about the regulation for non-conforming.
Yeah, the non-traditional structure.
structure. As I read that, for the purposes of this section, all residential structures under 750 750 square feet shall be considered a non-traditional structure as well. So this one is 750 square feet, and 750 is not under 750.
Okay.
The way the definition in our planning and zoning, all residential structures under 750 square feet.
Okay.
It doesn't say 700. It doesn't say 750 and below it says under 750.
Okay, their plans are to build a 30 by 20 foot cabin. And so I think they were erring on the side of caution just in case it fell just under 750 square feet.
It was 30 by 20, 25 by 30 in their application.
Yeah, sorry, is that what I said?
30 by 25.
Right.
So that's
30 by 25 on the outside dimensions.
Yes.
So that's how we go by on square foot, is the outside dimension or is it inside?
you tell me.
I don't know.
I think it's inside. That's how realtors, when you sell your house, they measure inside.
Because if you go inside,
The appraisers measure outside.
Yeah,
So
for appraisal purposes, they just measure the house.
Outside, okay.
So I guess, that's up to your board if you want to return this back to the planning commission for discussion.
no,
You have the ability to do that.
I don't want to drag this out any longer than we have to. I mean, but to me because there's nothing in the permit about being a non-traditional structure in the resolution that you presented us. The only condition is that if it is used in short-term rental and they have to comply with current zoning regulations, then I'm fine with that. I know Russ Evie had mentioned during that meeting a push nationwide to make these type of structures a landowner right rather than a zoning regulation. I think that's something we need to look at in the future. I know this is the second one of these permits I've been through here in the last 6 months. And, keeping people on the farm, keeping families intact in Marion County is pretty important. And with the shortage of housing, anything we can do to make it easier for residents of Marion County to keep their family at home, I think is a good direction we should take. But I just wanted some clarification on the non-conforming.
Okay. Are there any other questions?
no, just probably need to address the text.
Okay. The resolution does say that if the cabin is used for short-term rental in the future.
Okay. Any other?
I know Scott's boys at a young age have been running all that equipment for their manure spreading business. So if that helps them out.
So you would need a motion to accept, to adopt the resolution.
I make a motion to accept this resolution as written.
2025-07.
2025-07.
Second.
I'll second it.
Any other discussion?
Sharon, these tiny homes, a lot of them stay on axles. Would they fall under the same, if somebody pulled one of them in their yard?
Yeah, so there's a section in our regulations that refers specifically to non-traditional structures being used as so like shipping containers and non-traditional type structures, and then it also addresses the size.
And trailers are included in that as a non-traditional. So if it stays on
The axle.
it's actually
Consider it a trailer.
considered a trailer.
You gotta buy a tag. That's how you get the property.
Are tiny homes licensed like that?
As far as a trailer?
Tag.
Yeah, most of them have a a tag on them. Some of them don't have tags on them. That's because they never moved them, never put them on the highway. Alright. We've got a motion and a second. All those in favor?
Aye.
5-0.
Did you second?
You can let him have it.
Okay.
Not hanging out here with a motion. No second, so I'll take a second anywhere I get it.
Okay.
All right,
So
next.
I believe the next item, and I believe Brad is online. So for the essence of his time, I'd like to go ahead and discuss the topic of permit compliance on the Sunflower Wind Energy project before we move to the special event application. And I believe that was a request made by the commission last Monday. So I'll
Yeah.
listen for your questions, concerns.
Yep.
Okay.
And I don't have a copy of the conditional use permit for that facility, but
Thanks for saving us.
It's a calloused hand right there, not worried about getting bit.
the staff report from June 3rd, 2019, regarding that cup. Section number 8, no light shall be installed on the tower unless required by FAA. If lighting is required, then only installation of red light shall be permitted, blah, 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 blah. Lights beyond the minimum requirement not required in order to prevent potential disturbance to surrounding property. It's the staff's opinion that the use of proximity sensor lighting or radar-based obstruction lighting control be used on those towers where lighting is required by FAA standards. If I remember right in the cup, it says one of the conditions is that the ADLS lighting system be installed.
Yes, that's correct.
And you say that they are in compliance with that provision of the cup, and yet the intent of that provision is that those lights, that ADLS system be installed and functioning. In October 25th, 2023, their representative said that Sunflower's Turbine had implemented an aircraft detection lighting system installed during construction. The system uses surveillance radar to track aircraft operation near the wind project. The lights are activated when aircraft enter the area and deactivated when they depart. The system, she said, provides nighttime conspicuity on an as-needed basis, reducing the amount of time that the obstruction lights are illuminated. Now here we are, a year and a half later, and the lights are still blinking. So my question is, how do you justify saying that they are in compliance when the obvious intent of that cup and the provisions of that cup were that these lights be installed and that lighting system be implemented? Functional.
So the ADLS system is installed. They have the lights on each of the 76 turbines. There's an ADLS tower. They're dealing with a warranty issue right now. And I know this has been a long time, and they have weekly or daily conversations with the manufacturer of those lights and the construction company that they have working on those lighting systems right now. They have FAA 7460-2 records showing that the lights are in compliance. When the ADLS lights are not functioning like they should, they default to blink for safety reasons. So they're therefore compliant with FAA. The recent
I understand that they're compliant with the FAA, but they're not compliant with their cup.
Okay, so what I'm getting at here is that they're actively they're working through a warranty issue. They have brought back the construction company to work on those lights, replace those lights, whatever they need to do to get them working, and that will be happening within the next couple of weeks. You'll see those lights starting to function like we had intended for them to over the next several weeks.
That's what they said back in July.
Okay, so what do you propose we do about this?
Well, we have provisions in our zoning that allow us to fine if anybody else had a cup that they were out of compliance with, we could fine them $500 per day per violation. Am I correct in that?
So I think that you would have to prove that they're not being compliant. And I think that that would be a good question for an attorney.
Well, the lights are still blinking, so obviously something's not working.
So does the board wish to obtain our wind attorney to determine whether they feel that this would be non-compliance?
Want to comment on that? Yeah, Brad, can you comment on that?
Yeah, Sharon and I have talked about this and looking at what compliance requires in terms of CUP action or fining, which is not just administrative, it's quasi-judicial. And we can go ahead and have the consultants that we utilized in terms of the developing the final documentation that we're referring to here, take a look at that and see if they think that it would qualify. Generally speaking, I'll be candid, if the developer is making a conscientious effort toward remediation on anything that relates to a potential non-compliance issue, generally we're not going to be in a position to sustain those fines or any kind of a more strident action against them in terms of suspension of or revocation of the CUP. We can go ahead and get that opinion if you would like from them. Quite frankly, given the people that assisted with that part of the process, I would want to get their opinion and not just rely totally upon mine in that instance. I think staff-wise, Sharon is looking at it as well and saying, I think they are generally in compliance. I understand Commissioner Dirk's concern about, well, this has gone on for many, many, many months. But I think before we go into the process of aggressively pursuing that, we probably at least want to have some kind of an opinion to back us that this really does rise to the level of an absolute noncompliance or some form of dilatory behavior on their part that qualifies it for that purpose.
That,
And we can do that if that's what the board wishes.
Good question. Brad, what would that cost us to get that opinion?
That can be significant. I mean, again, it's legal fees, and Pat Hughes would probably be the one doing that. You can spend, I don't do his billing, but you can spend several $1,000s at a minimum getting an opinion like that. But that tends to be money well spent, because if you put yourself in a position of making the assertion up front and are not able to substantiate it or to sustain it in front of a judge, they have the ability to come back against us for fees as well. So it gets to be a little bit of an exposure concern, and my approach to that from the county's perspective is always going to be somewhat conservative, because I don't want us incurring additional expense that is throwing good money after bad.
is there any text that lay out, say the turbine isn't actually working, or the lighting system isn't working, or anything isn't working and functional, they have a set amount of time to get it back working?
Reasonableness is all that's the standard
That's all it
generally
says,
in all of
reasonable.
those. If you go back through them, because each case can be different, a turbine out of commission, for depending on the reason, can be anywhere from a 2-day fix to a 2-month fix.
Right.
Lighting, if you're using a subcontractor, now you've got another party you have to compel to show up and fix something on a warranty basis or an extended warranty basis, and getting them in here through no fault of the developers sometimes can be an extended period as well. And I know it's frustrating from that perspective, but that's just the reality of how a lot of that stuff works. And it's difficult for me to be able to say, okay, well, this is a bright line, absolute um, violation. They have generally installed what they were supposed to. We've got functional questions about how they're working. They're making the assertion that it's a warranty matter, and that they have continually, in good faith, been pressing the company that should honor the warranty. And I think the indication most recently, I haven't talked to them, but Sharon did, is that it's several weeks, and they hope to have all of that resolved and done. Now, you can continue to hold their feet to the fire with that and say, all right, then I want this back on the agenda in 2 weeks or 3 weeks or whatever you think is reasonable. And if it isn't done, you've begun to build your case through our minutes that reflect, hey, we gave you every opportunity to take care of this in a way that was orderly for you, and you still didn't get it done. That tends to be your better approach when you go in front of a district court judge, for example, if you're going to take action in a project like this, because your logical solution to it, besides fines, is to impact the cup in some way. And then you're talking about a pretty healthy investment that's in place on this thing. So they're going to certainly you'll have their attention.
As part of resolution 2019-21, section 7.1, actually article 7, event of default. That clause says that if, and I'm a non-lawyer speaking here, saying if we tell them they're in default, we give them 60 days, a 60-day cure period. At the very least, this county needs to put them on notice that we feel they're in default, and give them put them on notice that they're not complying with their cup, and initiate the articles in this resolution that require compliance and remediation.
And I would still, sorry, I would still encourage us to determine whether this is a default or not, like the interpretation of default. If we're going to pursue sending a letter to them and pursue this, because if this winds up in court and it's determined that our interpretation is incorrect, then the county may be responsible for reimbursing the other party's reasonable attorney fees, costs, and expenses incurred. If you skip down to section 7.2 right there in that comprehensive development agreement that you're looking at.
And that's what I was alluding to earlier. I don't disagree with, you don't want to just sit and stare at it. If I understand okay, it looks like it's not in compliance, and why is that? And it's continued to languish. If you want to put them on the clock more formally, the typical steps we would go through, at least to do our due diligence, is to have our consultants who were involved in additionally beyond my review and everything else that we did with it, indicate, yeah, I think you probably have a claim here that's reasonable for all condition. Then you send your letter, which is indicating that it's our assertion that you are in default, and we do that in good faith based on the professional advice that we're receiving from the people who help prepare all of this. And they do, that definition is, as you read it, everyone can see that's a little subjective because you can't anticipate each and every circumstance or contingency where this argument might come up. Getting that in place and then sending them that, you do put them on the clock. You're at least, if you wish to do that, putting them in a position of, hey, you don't get an indefinite period of time to do this. We do think it's a default. And if they don't believe it is, then they have the ability to respond to us in a timely way and say, we don't consider this a default and here's why. So we at least know the parameters of our argument and where the potential liability lies if we go forward with the logical conclusion of this is either assessing fines and punitive measures in some way that are well beyond compensatory, at least that's the way they're worded. But also you have the ability to start to impact the use of the cup. A temporary suspension, a full suspension or revocation of it, in an extreme case. And I'm not advocating for that by any means. I'm just saying those are your sources of relief here. You're not without some supervisory and jurisdictional powers with these, and that's the reason they're written into these agreements, so they don't just get to do what they want when they want. But they also are able, in an arm's length transaction, to have the ability to respond in a reasonable fashion, get something done. And reasonableness by your and my standard on a day-to-day basis for something can often be interpreted very differently when it's a development of this type, and all the parties that are involved in achieving a compliance result.
And Mr. Dirks, I would like to add that I don't disagree with you. I understand that this is frustrating for people that the ADLS system is not working like we had hoped it would at this point. I'm actually the one you read right out of my staff report. That was a condition that I suggested. So I'm not saying that I disagree with you in that I would also like to have the ADLS lights working like we had intended for them to. But I can also tell you that I've spent a lot of time being deposed and sitting through lawsuits and have the understanding that if we're going to make a claim, we have to be very sure and be able to substantiate that claim. Otherwise, we'll be spending a lot of money on attorneys for something that we're probably not going to come out on top of.
I also don't want to give the impression that we're reluctant to enforce, because the whole purpose in putting that agreement together and all the months that were taken in that negotiation was so that we could enforce.
Sure.
But it's a fairly deliberate approach. And I know that's frustrating. A lot of people are going, how can a lawsuit be on the books for 3 years, 5 years, 7 years? Some of the things that I end up negotiating for months, it gets into all the weeds and the subtle nuances and all of those things that go with it. Do I like it? No. Have I ever really found that to be something I'm comfortable with in the practice of law? No, but it's a reality of what we deal with. So we need to be fairly deliberate in our approach as well. I don't have any problem if it's the wish of the body, of the board. Okay, put some heat on this. Contact our consultant. I mean, I can sit here and say, well, here's what I think with regard to the compliance or non-compliance of the issue, but that tends to be a very specialized area of law, and part of the reason that we spent money at the time with these was to have someone in place who we could call in a case like this where we're going, okay, what's our downside? If we just breathe fire on them and say, you got 60 days to clear this up because we're going to consider this a default right now, and it's been in place for an extended period of time and we're tired of looking at it or confronting it or dealing with it, we can do that. But I'm still going to probably advocate that we at least get that additional opinion from the people that were at this from inception. And then if they're like, absolutely, you've got a clear-cut case of default here that seems obvious to the layperson, but I still want to hear from them that that's the case. And then we have the remedial measures set out in the agreements as to what we do and how we do it, and the timeframes under which they're then required to operate. And we hope that we don't find ourselves in a courtroom, because that's the last resort. And I don't think they would want that either. They've got a 40-year agreement with us. And I think they want to try to be as perceived as responsive as they can be.
All right,
They
Brad.
really do. I know they're very, sorry. I know they're very upset with the company, and they feel like they've let us down in a way too. So they want to do everything they possibly can to get this working.
I'm gonna propose something, rather than just keep kicking this around here, that we, rather than having Sharon come and defend their case, even though I know you're not doing that, and I know that what you've done for the other wind farm that never took place. So is there any way we can get a sunflower representative here on March 3rd?
I don't think it's an unreasonable request.
And then from there, we can talk about the 60
You
day.
deal with them. I do.
Jonah, do you want the Sunflower, or do you want the equipment manufacturer who has failed Sunflower?
Well,
But this is a third party,
yeah, they could bring along whoever.
Sunflower could bring along a
Yeah.
representative.
because somebody has
Our
failed
agreement, our
Sunflower.
agreement's with Sunflower,
Yeah.
so if they wanna bring somebody else along to defend their case, they can do that. But
Just so we get an answer.
Yeah.
I mean,
and then we can
'cause I don't wanna
set the
spend money
timeline.
on getting another legal opinion. That's what we're learning, we spent a lot of money for
Tina,
nothing.
what's your
Sorry,
professional
I have,
advice?
I'm trying not to say
I
anything
know.
here, but, I understand what intent is and what we tried to do, but what the conditional use permit that was approved and that resolution states does not say that it has to be functional. It does say it has to be installed. So that is, when you look at the actual documents, I think that is where you should have that legal opinion before you put them on notice. It doesn't hurt to visit with them, but I don't think you start a timeline there. You can show that you visited with them and asked them about it, but I think that if you wanna move forward, you really do need that legal opinion saying, based on what we have passed and what all the agreements say and the wording included, whether we would have a case or not. And Yeah, sorry, there was something else in here too that,
I would still like to have somebody here from Sunflower that tells me that they're trying.
right. Then the other point, somebody asked something about if a turbine is,
Yeah.
not functional
Well,
for a certain period of time. I think that there's, something in our regulations, like Sharon, I'm sure knows, but I think it's like a long period of time that they cannot be functioning before they.
Turbine usually heals itself. That's a revenue stream where light is not, so.
Right.
But Sharon, the way I understand it, if I'm not wrong, you said they're gonna try to remedy this in the next 2-3 weeks? Or at least come up with an answer?
Yes, they've basically been fighting this warranty case. You know how warranties work. No one wants to take the claim because there's a lot of money involved in it, and so they're on top of that. They've been basically fighting this with that company for months now. As you know, Mr. Dirk said that I've been saying this for a long time now, but in a recent conversation, I believe it was last week, the operations manager assured me that they're making progress on this. They have the construction company lined out to come out and start. I believe they have to replace each light on top of each turbine, and then it will start to function as we expect it to with the ADLS system by strings. So you will start to see clusters of turbines that have the lights not blinking all the time. And as this system, as they're replacing this and fixing this system, it'll work its way out to the far ends of the project area. So, over the course of the next several weeks, this is going to be happening.
So why don't we just start
To get this in writing from them,
That's why I want a meeting with them.
that's where I would start.
why don't we start the clock then from today? That if there has not been anything done in the next.
That would require a legal opinion.
You would have to
I would-
provide some
I would say
official
the legal
notice.
Opinion would come then. If they haven't met what they say they're gonna do, we're gonna get this thing resolved in the next 2 or 3 weeks. Then we get our legal opinion and go down the road.
Okay.
Because what Sharon's telling me is they've been in regular contact, I guess, or do you have to contact them?
We have a monthly meeting, and then also I'm usually on the phone with the operations manager at least once a week.
Does that make any sense?
No, yeah, I mean, last thing I wanna do is cost the county money, but I do wanna hold their feet to the fire.
Yeah, we can't just say, well, they'll get it done. 'Cause, you know, how big
Obviously
company-
not, you said that it was, what was it? October 25th of 2023. Yeah.
Yeah, it's.
I mean, that's,
In July 1st of last year, this commission sent a letter to Tom Britton saying that they were all fixed but 12 and they were working on those, and yet the lights continue to blink. I get this from my constituents. It was brought up at a meeting Sunday. It was brought up at the last planning and zoning meeting. I mean, at some point, we have to explain to the citizens of Marion County why we're not enforcing the intent of this COP. And I'm tired of trying to explain it to people.
Sure. I didn't believe Tom was in your district, but maybe I'm wrong about that. Yeah, I mean, I understand we can probably get someone to come and talk about this, but before there are any claims made, I would prefer to get a legal opinion on the county's end. Before we start any type of letter that's saying that they're not compliant, I feel like that would just be smart on our part, because if we're going to represent ourselves in court, we better have our ducks in a row.
I think it could be appropriate, though, to send a communication, whether that be from me or on behalf of the board, just to let them know that we would like to hear from them, see if they can come in and explain this in person, and that we want to see progress, or we may have to be looking at the possibility of, some sort of legal determination or legal action.
Get it in writing.
Sure, I don't disagree with that, Tina.
If that would help satisfy the board and.
Gotta start somewhere.
We can walk and chew gum at the same time too, and we will get the legal opinion at the same time we ask for a meeting.
I don't think we're setting ourselves up for any type of a lawsuit in questioning their compliance. Obviously, their intent in 2023 was to install these and turn the lights off. I mean, to me, the question of intent is not a question. They intended to have these functioning.
It worked for a couple of weeks.
And they're not. I don't think we're setting ourselves up for, no, we don't want to send them a fine for 72 towers for the last year and a half, but it's not unreasonable for us to ask them to comply with their cup. And I don't think we're setting ourselves up for any type of a lawsuit in doing that.
Well, in the end, the buck stops with the wind farm company. It's frustrating because it's no different than us dealing with trying to get a bridge paid for, 2 years later.
Or flood damage 3 years later.
And it's the same kind of scenario.
But if we don't start, we don't fix it.
It's always the big guy looks down upon it.
So regardless on whatever else, I'd still like to have a rep from.
Yeah, I think it'd be
on the
good to hear
3rd.
from him.
That gives a couple weeks. And surely it can make time for a meeting with us.
It'd be nice to hear from both wind farm companies at least once a year. Just to, kind of go over their operations and what they're doing. What are you doing for that?
It'd be nice to hear from Diamond Vista what they're doing in regards to the legislation passed in 23 that requires it on all wind farm systems. And I know there's a lot of, that was written by the wind company, so it's got a lot of loopholes and a lot of leeway, but
As long as
Build
it's a
at
meeting.
a certain time,
yeah,
are they required to?
yeah, by state law.
As long as it's a meeting based on government regulation, I think that'd be fine. Just singling them out. Never been on their side.
Maybe
We're not doing that to other companies. So, but if it's a government reg, then yeah, we should know if, how is this going to affect you? How are you gonna get through this?
What are you doing about this? What's your timeline?
Maybe we should call both wind farms.
And yeah, in that particular one, NERC or FERC regulate that more than likely. I don't know about that one, but that's regulated on a national and state level. So they will force them to comply with that on the Diamond Vista project because it's already a project in existence before that legislative bill went through. But yeah, so who would you who's going to write this letter to request that a representative from Orsted be available at a meeting to come and talk about this.
I think we have a professional.
Tina could handle that, I think.
Is it okay if we do it by email as long as we have good
Yeah.
communication? Okay.
Fine, as long as
Does
nobody
anybody,
replies to the email, then they can see it.
yes?
Yes.
Sharon and Brett, I'll get with both of you to make sure I have that worded appropriately and just so that you know when that goes.
Okay,
Okay.
thank you.
And Sharon to get the contact information of the appropriate person, so.
Okay.
Any more discussion on the other part? We got a meeting with them, that was one half of it, but the other half was what you brought up, so I just want to make sure I'm not shutting it off too early.
No, I mean, let's meet with them, see what they have to say, but we need to start somewhere. Cause
That was said.
I do appreciate your diligence, Mr. Dirks.
I'll keep it up.
I won't let it go.
I do not doubt that. Okay,
All right, can we move on to the asphalt plant?
yes, if you're all ready for that.
Yes, I think we
Okay.
at least started something in the other way, so.
All right, so Max Van Arsdale applied for a special event permit for a temporary asphalt plant near Lehigh on Highway 56. There's, sorry, let me change gears here. Let me wrap my head around what I'm trying to say. Yes, it's proposed to be 3/4 of a mile east of Lehigh on the north side of Highway 56. And there's also a plan for their layout there, what they'll be storing and the direction of ingress, egress. They do have a lease with the property owner there. APAC is licensed and bonded. I'm looking at these conditions here. They have stated their operational hours in the application. They'll have a traffic control once the project is going. I believe they tend to mobilize in March and start setting up the plant. And their project will run through, I believe it was September at that particular location. Okay, yeah. So July will be they'll mobilize in March. And July is when they'll start the project and have traffic control in place. Do you have any questions about that or a motion to approve that? Everything's pretty well outlined in their application.
It's always an asset for Marion County to have an asphalt plant close.
Oh, absolutely.
I'd make a motion to approve the special events application for APAC.
Second.
Any other discussion? All those in favor?
Aye.
Aye.
Okay. All right, I believe that is all I have. Do you have anything else for me?
No.
Stay warm.
Yeah. Luckily, I don't have inspections outside today. Thank goodness. Okay, thank you.
Thanks, sir.
So in your packet, there was information, those revised estimates from EBH, so I just didn't mention them earlier, but they were in there, so.
Clark was digging into that. Did that look all right to you, Clark?
It's $500,000 less than what?
It was a good catch. I didn't see the number dispute, so.
I'm sure we paid for those estimates, so.
Actually,
Our
we
money's-
don't, we didn't.
Until it's kind of something they do, I think, in order to help us get the cost share.
Cost share.
Cost share application just opened yesterday as well, so just so you'll know, I think the deadline is the middle of March.
Are
So.
fortunate this year. Because if we are, we can even bring it down if we have an asphalt plant around.
Right, yeah.
Okay. Yeah, alrighty, so it's Brad's time. Yeah. He's still on, if not.
Actually, I am. I've got a couple of minutes. I wanted to mention, I'd made the revisions to the burn regulations, but on Friday received some additional suggested changes and incorporating some additional documentation that needed to work through over the weekend. So I will work with Tina, but I anticipate perhaps bringing that back to you on the next agenda.
That'd be on the 24th.
Yeah.
Okay. Anything else?
That's it for today.
Okay. Commission comments. Snowy day. All right,
Be very careful.
motion to adjourn.
Second.
All those in favor? Aye. 5-0.